Hello everyone, my name is Francesca. I'm a PhD candidate with the program Law, Science and Technology, Rights of the Internet of Everything, founded by the Action Marie Sklodowska-Curie. Today I would love to talk to you about this journey that took me 3 years to research my thesis in this project, which concerns the legal liability of IoE or IoT devices in the smart home. The thesis has been my principal interest, but I did not do just that. I curated quite a lot of publication, both on peer-reviewed journals, conference proceedings that were peer-reviewed, and also blog posts. And I actively participated by submitting abstracts and papers to this list of conferences, and I actively organized one concerning the interrelationships between technology and the climate change in collaboration with Mykolas Romeris University and the Italian Embassy in Vilnius. Coming back to the thesis, this work has the ambition to give guidelines, but actually sometimes, given the fact that it was very general, the title, I had to restrict the field of investigation to product liability, we will see, and it will take somehow a monographic perspective. It is structured in 5 chapters. It has already reached the minimum level of 70,000 words, and you can see how I decided to divide my 3rd year by consecrating it almost exclusively to the drafting and research of the thesis. And my first chapter is about methodology. Despite my background is of a legal scholar, I decided to deepen my knowledge of the IoT technology, which is the one giving rise in the future to the Internet of Everything, IoE. In this way, I think I was more clear in my legal analysis, for which I adopted a comparative approach. Then I had to exclude something such as criminal law and administrative law. In the 2nd chapter, I focused in the beginning on the definition of the IoT, on its very physical structure and the concept of IoT itself, and how it is related to the smart home whose origin was more ancient than we think of, and it was connected, in any case in the 20th century, more to the energy policy and electricity policies than to the IoT. Also, I also wondered, are there any ways to try to categorize the objects for the home that are smart? And I came up with 4 main criteria. The first one you see is the novelty criterion. It means that basically you have to distinguish whether the object was already present and was just updated or not. The autonomy criterion that makes them closer to maybe robots, even though it's a bit arguable, because the IoT is really in between the AI, because it's connected to the cloud, and where there are also algorithms that can perform data processing functions that are really, really important, and they are considered AI and robots. One of the last criterion is according to the function, which can be also mixed. In fact, a wearable such as a smartwatch can have like a normal function, commercial functions, telling the time, but also healthcare functions. And finally, the last but not least, the EU gave its own classification of the IoT within its last report on consumer Internet of Things. And what I deal with in the chapter 3 is the state of the art, but from a law perspective. Especially, I focus on the so-called data law, and meaning data protection, e-privacy, but also the Perspective Data Act and how it impacts on the IoT, and the update of the contractual law and of consumer law, such as the two directives on the sale of digital goods and supply of digital content. And I found out that the last bit of the puzzle that needs to be updated is the product liability directive. I excluded the safety regulations because it's more connected to administrative law. The last part of the third chapter instead focuses on the regulation of AI, and especially of its liability, which is still in the making. But I argue that the division that is present within this regulation between high risk and low risk application will apply to the IoT as well. And it's very likely that high risk IoT application will follow the regime of the liability of AI, which will mostly be like strict liability, and in the intention of the expert group of concerning new technologies, tort liability for the low application, which in this case could be the domestic IoT, but I don't agree fully with that. I think that strict liability can also be applied to these objects, because the product liability directive, despite all its defects, functioned well, at least at the level of harmonization. Hence, the fourth chapter explores the functions of liability, not only from a legal point of view, but also from a more sociological point of view. And what I argue is that there is the main problem if we want to update the product liability directive, which is a project that is ongoing, is to find an appropriate legal base, because according to me, Article 114 of the Treaty of the Functioning of the EU is not the perfect legal base, because nobody has ever explained the relationship between the digital single market, which since the beginning comprises also an approach with fundamental rights and risk assessment, and the digital single and the single market itself, which is referred to brick and mortar economy. This entails that the division of competencies between states and the EU must be very well evaluated. Chapter 5 concerns the Product Liability Directive. The core of the thesis, I explore its history and the legal models preceding it. I give a quantitative and qualitative analysis of all the judgments rendered until nowadays by the CGU, and I point which can be the interrelation with the GDPR, the sale of digital goods, and the directive concerning the supply of digital content and digital services. And finally, I make a comparative part concerning the American model of product liability and its application to the IT domestic technologies, because there have been quite a lot of cases in the last few years concerning these objects, unlike in the EU. Finally, to sum up, my main conclusions are that the liability for IoT will be most likely be divided in between high risk and low risk application, that updating the PLD is possible. It needs to be done by taking into consideration the GDPR, the Directive 7070 and 7071 2019 and Data Act, and there must be a new way to find the balance between the competencies of member states and the EU. I thank you for your patience and attention, and I hope to see you soon. Thank you.